here to help us understand their legislation better. And so we'll skip around. I see Representative Birch, Elliot Birch is here. We'll call you on. You can just have a seat here and grab a microphone. We're going to look at House Bill 611. Representative Birch, please take it away.
Thank you, Mr. Chairman. Ladies and gentlemen, I appreciate the opportunity to be here. House Bill 611, what it does, the Mississippi Board of Law Enforcement Standards and Training, they have entire authority over licensing or certifying police officers. Whenever they have a hearing, they determine an officer has done something that requires his certificate to be suspended. They have a hearing in front of their board or a select group of board members. This bill would just require them to provide that officer with discovery, with the information related to the infraction. Right now, what happens is the officer receives a letter that just says you've violated the ideas of what a law enforcement officer should be, and there's no way to get discovery even through request. That's a brief explanation. I'll answer any questions.
Great explanation. All right, any questions? Anybody? All right, for a motion? You've heard the motion. All in favor say aye. Any opposed, nay. The ayes have it. Thank you, Representative. We appreciate you.
Thank you, Mr. Chairman, and thank you for allowing us to explain these bills today. So House Bill 1142 will just simply amend the notice process for the issuance of judgment nisi. Current law requires that the clerks notice bail agents when a judgment nisi or a bench warrant is issued via certified mail. That has become costly on the counties because oftentimes they have to do a lot of those notices because people don't show up to court. What this will do is just bring us to the 21st century and allow the counties to notify the bail agents via electronic notice or personal notice. This comes at the request, Senator Hill, this comes at the request of Jeanette and Judge Touchstone from our district. And the Clerks Association supports this legislation. So that's an explanation. It's just simply aligning the bail agent notification with what attorneys are required to receive, which all of our notices now come electronically in an effort to save the counties and our clerks some money.
Question. So the bail agents will have to get, is it through the MEC?
So that is the way this is drafted. If MEC comes on board and can make that happen, they will be able to receive it via MEC. And I talked to MEC and they said that is something they can certainly do. In the meantime, email notification will suffice the way this language is written.
Okay. Senator Simmons.
Thank you, Mr. Chairman. I just want to follow up from the question that the chairman raised. Will it still be on MEC where the lawyers, all those that are interested parties in that particular case would get an opportunity to see that notice has been filed?
Right. Right now, we, as attorneys, we already get the notice. So we receive the notice via MEC. The bail agents, the statute requires the clerk to send them certified mail. So this is just giving them, bail agents are a licensed profession regulated by the state. It's perfectly acceptable for them to receive their notice electronically like everyone else. Okay. So that's what we're doing.
Okay. Thank you. Thank you for yielding. Thank you, Mr. Chairman.
Yes, sir. Any other questions for Representative Owen? If not, for the motion. You've heard the motion. All in favor say aye. Any opposed, nay. The ayes have it.
Right. Thank you, friends.
Appreciate you. All right. Representative Shonda Yates is here with 1404. Appreciate y'all all coming out early this morning.
Thank you, Mr. Chairman. What House Bill 1404 does is create the crime of fraudulent utility conversion. During hearings that we had in the House Select Committee to Revitalize Jackson, we discovered that there was an issue with apartment complexes collecting rent that included payment of water bills and other utilities, and then failing to remit payment of those utility bills to the utility provider. So the tenants believed that they had been paying for water for years, when in fact that money was not being remitted to pay the actual water bill. Then it came time for the utility company to cut the water off, and all of these people were very much surprised because they had been paying that water bill. The bills are in the name of the property owner, the apartment complex owner, not the individual tenants. So there was a huge issue. We have $400,000 past due water bills in some instances. We learned that this was an issue in other parts of the state as well. Last year, Louisiana passed almost an identical law to address this issue there. So what this does is if you are a person who is responsible for collecting and remitting payment of utility bills as part of collection of rent, and you fail to do so, you can be charged with this crime. The penalties, as you'll see in the bill, are stair-stepped depending on the amount that you convert or embezzle from your tenants. The less money, the less severe the penalty. The more money, the more severe the penalty. I'm happy to answer any questions.
Senator Simmons.
Thank you, Mr. Chairman. Representative Yates, what is the mens rea requirement that we are placing upon these companies or these agents of companies who may collect rent and may have an employee who just failed to remit the rent or sat on their desk for a long time? I'm just looking at the language starting at line 25 through 30, where you can get up to 20 years in prison. And so I certainly don't want people's water bills to be collected and not paid, but I am a little concerned about our property owners and our constituents who are engaged in property and being faced a crime of 20 years when they may or may not have known or intended for the utility bill not to be paid or remitted.
Sure. And that 25 years is, I believe it's more than $50,000 that has been, I don't think anybody's just forgetting to send $50,000 worth of utility payments in. But we did get a lot of what if questions when we presented this on the House floor. What if somebody's bank account is hacked and they lose all their money and they can't pay? We could certainly go down the rabbit holes of what ifs. I have no issue with adding some language that says that there has to be some intentional conduct. But I do want to make it clear that I don't want the language to be so severe that no one can be convicted under this.
Yeah, and I know now that the bill is the property of the Senate, and I certainly appreciate you saying you don't have that problem, because my follow-up question was going to be, are you opposed to additional language or reverse repealer to try to make sure we are doing what you want us to do, but at the same time, we don't have any unintended consequences?
My preference would be just an amendment as opposed to a reverse repealer. I'd hate to see things drag out longer than they have to. If you've got some language now or on the floor that you want to stick in it and then send it back to us to concur.
So at the appropriate time, Mr. Chairman, I do have an amendment. My amendment would be to track the language, Ethan, that we have for crimes, that intentional, willful, like that same language that to establish that the act was in fact intentional and willful before someone is actually faced with this crime. It established the mens rea that we need, or that is consistent with all of our other crimes. And so I'll leave it to you where to put it, but I want that language in there. That'll be my amendment, Mr. Chairman.
Any of the questions first?
Oh, sir.
Senator Hill.
Question. I would think that in cases other than mental or physical incapacity, that it would pretty much have to be willful to just not pay a bill if you're a landlord. So, you don't want, do you want to create a loophole that lets anybody off? That's a concern. And of course, I'm not an attorney, but it seems to me like, absent mental or physical incapacity, because even if they're going bankrupt, they're doing something with the money and not paying the bill. So that's just a concern.
The what if questions that we got on the House side involved, well, what if their bank account is hacked and they lose all their money for 30 days and can't pay? What if the IRS freezes their accounts? We went down a lot of what if rabbit holes that may or may not ever happen. But
Right.
I don't think we can protect against every single scenario. But I think the intent is certainly to punish those that are not remitting this. either intentionally or for some reason that's not legal.
I don't have a problem with it. I just don't want to create an amendment that gives everybody a loophole to get out of it. That was my concern.
Thank you, Mr. Chairman. And just to be clear, we're on the bill, not the amendment at this time. Okay, thank you. Representative Yates, thank you for your explanation of the bill. My question, and I know you've been hit with a lot of what ifs already, and this will probably be another one and probably one you've already heard, but one concern I have is with penalties this steep and with no language, like Senator Simmons mentioned, involving intent, all over the state, and I know, for instance, it's happening in Jackson County in a few municipalities, but it's also happened, I know, here in Jackson, where utility bills aren't sent, and so they don't. These entities may not receive a bill for sometimes well over a year, and I imagine sometimes these apartment complexes will have a very large bill that will hit them all at once. And so they may have a manager that's paying bills as they come in and not realize that this water bill hasn't shown up. And then, 18 months, 24 months later, they get a bill that's well over $100,000 for those services. And I don't know that there's any process for them to have to pay that. And then, they may be going to the utility company and saying, hey, we can't pay all this at once. Well, if the utility company doesn't work with them and instead goes and shuts off the water, are those entities then, facing fraudulent utility conversion charges?
No. So the way that it's written is that the person, the landlord, would have to fail to remit the monies that it has collected from the tenant. So if you are collecting $30 a month from your tenant every single month for water, that money needs to stay in your account to pay water bill. Whether or not you receive that water bill this month or next month, that money should be there. You shouldn't be using it for anything other than what you're collecting it for
Right.
from the tenant.
Well, and listen, I understand that, and thank you for that answer. But a lot of these apartment complexes in landlord situations, you may have surely you have that built into your payments. But if the bill doesn't arrive and you have a manager that's over your properties that's paying bills as they come in, and that's their job, and the bill doesn't show up, and you get hit again with say $100,000 or $200,000, I don't know. Are we saying these folks have to then have a trust fund account, or my concern, Representative Yates, is that we've got these utility companies that aren't, either due to faulty equipment or just due to mismanagement, aren't getting bills sent out in a timely fashion. But of course they're still going to charge you for those services, whether it be down the road or not. And if you get hit with a $150,000, $200,000 bill, and this utility company then says, this is owed, it's owed now, we're not going to work with you, we're going to go shut your water off. Well, then that tenant's dealing with water being shut off. And it seems to me under this bill that apartment complex owner or LLC, which is also kind of confusing because I'm not sure how an LLC can be subject to criminal penalties like that. And that's certainly possible with within the law, I guess, but it just reads a little odd switching between persons and companies. But I digress on my original point being that if a utility company is not willing to work with someone and says, hey, you've got this $200,000 bill, we're sorry we didn't send you a bill, but you've got this $200,000 bill, you either pay it now or we're gonna cut your water off.
So there's, I guess, two instances where that would happen. The first is you have a $200,000 water bill that's actually due, actually owed, and you have been collecting that money from your tenants for the last year or however long. What did the apartment complex do with that money that it's been collecting for water bills? Was it spending it on something else? Did it, as far as the tenant knows, it was sending that money in for the water bill.
Right.
In that instance, that money should be sitting in the bank account to pay that bill when and if that bill comes in. The second instance would be if an apartment complex receives a bill for $100,000 because there was a leak or some other issue, or there's a meter issue, something is wrong. This would not apply in that situation because it simply says that they are required to remit the monies that they have collected. So whatever they've collected from the tenant, they are required to pay. It's not saying they are required to pay the bill in full. They're just required to give the money that the tenant has given them as part of their rent for the utility payment.
Right. And again, I understand that. I think my issue is with maybe with lines 14 through 16, where it says, remit the monies collected for such utilities to the provider of the utilities. And if the provider interrupts the tenant's utility services,
Yes.
These landlords, if they're hit with a very large bill, most of your landlords aren't just going to say, oh, that's what that money's in my account for. We're going to send that in. They're going to want to ask, well, send me my usage, send me this, send me that. Well, if that utility provider interrupts that tenant service and says, no, you pay us this now, or it seems like we're kind of holding those landlords in a very tough situation where not only the utility company can say, I'm sending you a $200,000 bill and you're going to pay it, or we're going to cut this tenant's water off. And by the way, you might end up in jail for 20 years if you don't pay this. That's my concern.
I think the concern is, though, if they've been collecting this money from the tenant for the last year and it's not still sitting in that account, they have effectively embezzled that money from the tenant. They are only required to remit to the utility company what they are collecting from the tenant. If there's a dispute above and beyond that, this wouldn't apply.
So embezzlement definitely requires an intent requirement, I believe, right? I mean,
Sure,
if
and
you
I'm
accidentally embezzle something.
fine with that proposed amendment to
Right.
make that clear.
During the hearings that you had that involved Jackson Water and things like that, did you hear from people that said, we didn't receive a bill?
Yeah, and also it was all over the news. You had landlords that said, yeah, we just didn't pay our bill. But we were collecting the money to pay it, but we used it for something else.
Yeah, and look, I think that those folks, we need to do something. We need to stop that. I don't know that that maybe the unintended consequences of a utility company that we all know, I believe it was very well reported that the Jackson Water System, number one, they weren't collecting payments. Number two, they weren't keeping up with the utilities. And look, that's happened in many other. I have a city or several cities in my district that have done the same thing. And these customers will reach out to me and say, "Hey, I've got I didn't realize I wasn't getting a bill. If it was coming in, I would have been paying it." And they're in the same situation. They're using this water. Well, they're not looking at their bank account and saying, "Oh my gosh, I've got this $110 in my budget left over at the end of this month."
That's an individual. This is a very different situation where someone is intentionally collecting payment for a utility as part of someone's rent and then either not holding that money to pay the bill or misusing that money and using it to pay for something different.
Well, I think your answer there probably takes care of what my issue is. You said intentionally, and I think if we get this language added, maybe it would be better. And look, this is one of those instances where I do think maybe a reverse repealer would be better, just so that we could talk through these issues. I know you don't prefer that because we want to get something done. And look, thank you for your hard work on this and for all the work you're doing for this community and for this issue. But I just feel like there's more of these what if conversations that we really need to take seriously, because we can end up having some individuals, facing a 20-year jail prison sentences without having embezzled or done anything ill-intentioned, and I would worry about that. So thank you for responding and answering my question.
Of course.
Senator Wiggins.
Mr. Chairman, I actually have a question on the amendment, but I also have a question on the bill. So which would the chair? The bill. Okay, so to Representative Yates. So the easy one in line 18, there's the word juridical. Is it judicial? What is that? And then I also noticed it got carried over to line 23. What is juridical?
That is something that our legal drafting team put in there. I don't know. I don't know the answer to that. I can Google it.
Okay, well, all right. I didn't know if it was a typo or what. I didn't know if it was juridical or judicial or something, a judicial person, but so going on. And then So you're trying, from what I understand, you're saying is you're trying to get at the people, the entities that collect the money and then don't turn the money over to the city. Is that correct?
That is correct.
Not necessarily the tenant who's paying the money, or am I wrong in that?
Yeah, no, this would not have anything to do with the tenant.
Okay.
This would go towards the person who has collected the money from the tenant and then failed to remit the money that they collected.
Okay. And so whether that's an individual or a corporation or something like that.
That is correct.
Okay. Which I would, okay, so to that end, assuming, let's just say to the point you made earlier, if it's $50,000, generally that's a corporation, and corporations are corporations which at the end of the day can afford $50,000.
Especially if they've collected it.
Right, especially if they've collected it. And you don't put a corporation in jail, you fine them.
Correct.
Okay. All right. So then, Mr. Chairman, my question's on the amendment. Okay. Okay, it is. Thank you. We the House lawyers trumped us that time. There we go. Interesting. Yeah. So Senator Simmons, so if I understand your amendment, I think what your amendment is, the language that you're talking about is generally in criminal statutes. So for example, in false pretenses, it says if knowingly, willfully, and unlawfully, that language is in those statutes. Is that what your amendment is covering?
That's correct, Senator.
Okay. And
And the reason why is, well, first of all, let me just say generally, I don't think landlord entities and or corporations should be facing a crime for something that may happen in a business structure or. I mean,
but that happened.
I
There are
understand. I understand. I understand.
penalties
I-
against.
I understand it, but based off the bill before us, I just want to make sure we track and be consistent with if we are going to charge them with a crime or they face that mens rea, that language is there.
And so that language, knowingly, willfully, and unlawfully, creates the mens rea
That's correct.
that you're talking about.
That's
And
correct.
I think, and correct me if I'm wrong, but under case law and the Supreme Court has said that language creates that.
That's correct.
And if that language is not there in a criminal statute, or for example, in an indictment, if an indictment is missing that, then that is that defeat, that means it's not there and that's wrong against the defendant. Is that
That's
right?
right. That's right.
So by putting those knowingly, willfully, and unlawfully in the statute, then that creates the criminal intent that is required.
It does.
Okay. And so then in looking at lines 11 to 16, and Mr. Chairman, I may have an amendment to the amendment, adding knowingly, willfully, and unlawfully to in line 13, does not knowingly, willfully, and unlawfully remit the monies collected for such utilities to the provider. So that would be at the proper time, that would be my amendment to the amendment. Yes, so and change fails to does not, because in fails kind of is it was a mistake as opposed to intent. So my amendment to the amendment would be starting at line 12 is committed when a person receives payment for utilities from a tenant, but knowingly, willfully, and unlawfully does not remit the monies collected for such utilities. Aye.
A question on the bill, Representative Yates. This crime already exists. this is not a new statute. Is that correct? Utility conversion fraud, is this all new?
It's all new, yes.
Okay.
So, I mean, conversion exists, embezzlement exists, but this specifies specifically the crime of taking money from a tenant for the purpose of paying a utility and then failing to do so.
But 89-847 is all new. I mean, the only reason I ask that is because I'm looking at the strike-through version, and is this just updated from what was originally there? Because I have underlined language.
That was our amendment, our floor amendment that's underlined.
Okay, all right, just making sure.
Mhm.
But at the end of the day, most of these complexes are served by master meter, correct?
Yes,
Okay, so the tenant can't pay the bill
that's
directly,
the issue, yes.
all right? And then last I checked, most tenants enter into a lease agreement with a landlord,
Yes,
i.e. a contract. And usually the tenant doesn't get to draft the contract. Who gets to draft the contract usually?
the apartment complex, almost
Okay,
always.
so the landlord gets to say, these are the terms of you living here, including whether you can have pets or not, whether you can smoke or not, and how utilities are going to be paid. So the drafter of the document is the corporation or the LLC or the landlord. So they dictated the terms of how much that tenant pays for utilities, correct?
Yes,
All right. And usually, correct me if I'm wrong, you also enter into a contract with the utility provider as the landlord. There's an agreement. They're told rates. They're told, hey, if you pay late, it costs this much. So the landlord has the ability to, which the utility company usually writes that contract, but the landlord is in contract with a utility provider. Then that landlord enters into a contract with a tenant, and they set the terms, whether I want $30 a month, $50 a month, whatever it is, and then they don't pay. That's
correct.
what you're trying to deal with.
100%.
All right. And last I checked, municipalities can't take money they generate in water and sewer and spend it to pave roads.
Correct.
Okay, so same concept here. If you in your contract said, you, Mr. Tenant, are going to pay X for your water services, and you don't hold X out, and whenever your bill comes, on time, late, anything else, and you don't remit what you contractually withheld from the tenant, took from the tenant, then it becomes a crime.
That is correct.
Okay, because we're kind of off in the weeds about utility companies not doing their job correctly. But if I collect $30 a month and then all of a sudden I get a bill and I would have needed $80 a month from every tenant to meet my obligation as a landlord, I'm only committing a crime if I haven't remitted the 30. Is that
That is correct.
all right? Because I think the concept here, and we're trying to be fair to a tenant who does not have the negotiating power nor the ability to pay the utility provider. And they've entered into an agreement with the landlord, and the landlord controlled that language, and they've simply paid what they were asked to pay. And if the landlord fails to remit that amount, then there's a crime.
That is correct.
Okay, thank you.
Thank you, Mr. Chairman. And this is kind of in conjunction with what Senator Sparks said. And I think that he described a perfect world scenario where everything be. Are we aware, or have you heard from anyone that maybe in this community or in other communities around the state that have received large bills from utility companies after going, 18 months, 24 months without receiving a bill? Have you heard from anybody that that's happened to?
I have, yeah.
Okay. Have you heard of any situations when looking at these utilities in Jackson and found out that in some instances the meters and the reading systems were faulty?
I have.
Have you heard from anybody that said that and I'm sorry to get cross-examination, I'm just trying to avoid what-if questions, but I
Love
just
it.
want to make sure that you've heard from these individuals. Have you talked to anyone that had an amount that was charged to them that was more than what should have been charged due to these faulty meters?
Yes,
Okay, so that has happened.
it has.
Well, that is my concern, is
The,
that
the
if they don't,
difference is though, what hasn't happened is that in those instances where they're receiving bills, they're saying it's more than they should have been, they are not remitting the portion that they had been collecting from tenants for years to cover any portion of that bill.
yeah,
So they've been taking money from tenants,
Mm.
doing God knows what with it, and then saying, oh, well, we don't actually want to pay this bill now.
these water services, a lot of times when they're with a tenant, say if it's an apartment complex,
Mhm.
does that utility provider provide a separate hookup for each individual?
No,
Okay, so the apartment landlord could potentially have an issue with, you're charging me for all of these units. I didn't have a tenant in that unit, so they may actually have a valid argument that the bill is for too much. Is that correct?
they could, but they're still only obligated to pay the amount that they've taken from the tenant. And if there's not a tenant that they were taking money from, there's nothing to remit.
Would you consider it to be a friendly amendment if we added a defense to this bill that if a utility provider does not have in place a written policy for disputing bills, and then to allow that landlord or that customer to avail themselves of that full written policy to dispute bills? Could we add that as a defense? And I understand I'm not stating that in a way that it would go perfectly in, which is again why I think maybe a reverse repealer would be wise here, so that we could get that, because I do, we as you just said, we know this is happening. We know that people are getting bills for either too much or in faulty amounts, and I'm seeing it just with individuals in my location. They'll of course they go straight to social media and say, hey, I just got a $2,000 bill from a water company.
Sure.
Well, if the water company goes and shuts off that water and say that's a tenant in that house and not a landlord, that was a tenant there, well, then you've opened yourself up to a crime.
Not if the landlord has paid whatever they've received from the tenant for that utility.
So we're requiring them to just pay all of that up forward without being able to just.
No, so if you are collecting from your tenant $10 a month
Mm.
for water, specifically for water, and that's in your lease agreement, you have that $10 a month in your bank account. You go, a year and you've still got that $10 a month sitting in your bank account that you've taken from that tenant to pay for their water bill. You get a bill at the end of the year, you are responsible for remitting every $10 payment that you have received. And that's all you have to do as a landlord. If your bill ends up being $800 more than what you collected from the tenant, there's no responsibility. The only responsibility or requirement from the landlord is to pay what you have taken already from the tenant for that utility payment. You have to remit what you take.
Okay, no, I understand that. I'm not comfortable with the penalties, specifically the jail time involved in this, knowing that we have utility companies that aren't being forthcoming, or whether they're meaning to or not. We have a very poor system in place in a lot of our communities right now, and a lot of people are getting large bills and large amounts. And I understand what you're saying. Just pay what you owe.
What you took.
What
No,
you-
not even what you owe, just what you took.
Well, so how do we know? Is that is that in here that you have to submit the contract, and if they submit exactly what's owed?
Well, it says that they have to remit the monies that they have collected from the tenant. So if they haven't taken it from the tenant, they aren't responsible for remitting it.
Okay, yeah, and I understand that. Maybe I don't understand how apartment complexes work. I don't understand if water gets cut off to the entire complex if you don't pay.
Yeah.
Well, so that's where I don't understand how those individuals are going to be able to say, okay, well, we have 15 tenants. You're saying we owe this much. We're going to give you the $150 for this month, but you're still going to cut our water off.
The water would still be cut off, but they would not be criminally liable under this because they have remitted the monies that they collected.
Okay. Okay, yeah, Mr. Chairman, I would like to put to have an amendment at the proper time.
You recognize, Senator Ingram.
My amendment would be for a reverse repealer.
All right, any questions on the amendment? If not, all in favor of the amendment, say aye. Any opposed, nay?
No.
Close. All right, let's have a show of hands. If you're in favor of the reverse repealer, raise your hand. All right, if you are opposed, 2, 3, 4, 5. All right, I think the reverse repealer won the vote on that one. All right. So there's a reverse repealer now. Any other questions? Okay. Lively debate. Thank you all. Let's have a vote. Is there a motion?
It's all sufficient to pass.
All right, you've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you, Representative Yates. We appreciate you. All right, we're going to bump back up to the first bill on the agenda. This one, Representative Remack did come and visit with us about. Unfortunately, her son is requiring her attention up in DeSoto County this morning and could not be here. But nevertheless, Senator Sparks has agreed to talk about the bill, and we'll consider it now.
Thank you, Mr. Chairman. House Bill 525 addresses the crime of sexual battery and basically includes a minimum of 5 years for such convictions of sexual battery, particularly when the victim's under the age of 16. That does not, I don't believe, raises the maximum, but it does input a not less than 5 years, and then on a second offense, not less than 10 years. That is a brief explanation of the bill. I'd be glad to yield to any questions.
Senator Simmons?
Thank you, Mr. Chairman. Senator, I have a question. Senator Sparks, what happens with the current law when they are 36 months apart, like those situations where the victim is under 16, but also the defendant is under 16? Are we changing it? Because I know with some language where we leave that in the discretion of the court, and there is no reference to a maximum or minimum. Are we changing that?
That would be changed under this bill as drafted, that would deal with what you're talking about when the spread of months, because basically you're getting almost into the statutory rape category, that when someone is, under the age of 18 and has relations with somebody under the age of 16, if there's less than 36 months, that doesn't qualify. If it's more, it does. Now, bearing in mind, this is a sexual battery. This is not a willing participant. This would be an unwilling participant. So that would be potentially part of the distinction.
Okay. And so we are increasing it to a minimum of 5 years, mandatory.
That's the way I understand it, that it is drafted.
And because it's sexual battery, 97-395, according to our parole laws, these are day-for-day offenses, correct?
They are crimes of violence. I don't know if it's day for day. I would not dispute you if it's day for day on that particular crime.
Yep, it's mandatory day for day.
Okay.
And what are we increasing it from? What was it before we are proposing this mandatory 5 years?
I believe everything, and again, looking at the bill, everything that's underlined is new language. I don't see anything stricken. So I think when you look at this, the primary changes are that it's the not less than 5 years added kind of to each situation. I don't think it increases kind of the other penalty pieces. It just adds a floor, if you will.
And would it be a friendly amendment? I just want a little bit more time to look at it. I certainly agree with how serious this offense is. I just want to see the effect of the minimum mandatory 5 years for each area of sexual battery. Would you be opposed to reverse repealer?
I would not.
Okay. And at the appropriate time, Mr. Chairman, that'll be my amendment.
Do we know where this bill's, who's requested this bill? And before anybody says Senator Wiggins, he's against, raising penalties on sexual battery. That's not the case. I know you were. My question is.
I would never say that,
Why-
Senator.
Thank you. Where's this bill coming from? And is there an issue through our prosecutors and our judges or whatever that sexual battery is not properly being prosecuted, or there's things that are happening?
To answer your question, I can't speak to the genesis of this other than Representative Remack was a primary sponsor along with the other listed individuals on the bills, about 7 sponsors from the House. And again, I would be assuming other than just saying that there's a floor in it. I have not been contacted personally by the Prosecutors Association or the AG's office or anybody else. I'm just handling the bill on behalf of what was
You're
delivered
rocking
to
the
us in the
baby.
House. To a certain extent, yes, Senator.
It looks like we're changing it to a mandatory minimum. Are we changing any of the maximums?
To my knowledge, again, there's no strike through, so nothing's been eliminated. I would look at the second offense language on line 17 that, again, there's a minimum 5 years, 30 years on a first offense, and a second offense is a minimum of 10 and up to 40. If I go and look at line 12, you see the 30 and the 40 is there. So I don't know that we're increasing max penalties. I think more so the tenor of it is putting a minimum in.
And I would submit that these are day-for-day crimes. And it's on a sexual battery, it's 40 years. You're spending 40 years in prison. And
that's already the law though, right?
Yeah,
okay.
that's the law. And also that it being a crime, that type of crime, well, it's day for day. So that means you're not eligible for early release or anything like that. So I guess that's the question is, why are we doing this? Not other than to say a mandatory minimum is 5 years. Does something lead to this?
I don't know of any specific case or any specific issue. I think it is just the nature of the crime being what it is. And when the language is up to, that also means it could be 0. And so
we know
was
of
chosen to put 5 years in.
Do we know of any case throughout the state where a judge has sentenced a sexual battery convicted defendant or on a plea to less than 5 years?
I certainly wouldn't have that information. I don't know,
I'd be surprised if that actually happened. It's just, Mr. Chairman, do we know when Representative Remack may be back?
I don't specifically. I spoke with her yesterday. I think her son was in the ICU up in DeSoto County, and she and her husband have been taking turns staying there. So this was her turn to go back up and relieve the family. So I suppose she'll be back as soon as she can, but I don't know the specifics.
Okay, thank you.
Senator Hill?
Just a comment, and I can't remember specifics of the case, but I'm thinking it could potentially have to do with the school board issue in DeSoto County. I'm thinking maybe that judge did not sentence. I can't remember for sure, but that's something we might need to look at. That may be, I'm just
No, that's a fair.
thinking I
that's
think that
completely
may
fair.
be where
But-
it's coming from. I'm not certain.
I appreciate you bringing that up because I think I don't know all the facts in that
don't either.
case, but it was, from what I understand, it was a special judge who was appointed who is not from there. And it was, I call it, if nothing else, a one-off. And so we're changing the law where, from what I'm being understood, from what I've understood, the sexual battery statute as it stands has been a pretty darn effective statute. And both from all the things that we look at. And so that's what I was wondering is because of one thing like that, we're changing it throughout the whole state.
That's the only one. That's one that we know of. There may be others that are not high profile, but I was just going to
Okay,
mention.
no, I appreciate that. Thank you.
Well, if it's the will of committee to lay the bill on the table until Representative Remack can get back and more fully explain,
I would make that motion, Mr. Chairman, table subject to call with the idea that Representative Remack could come back. And now that we've had this discussion, maybe she can know where our concerns are.
All right, you've heard the motion. All in favor say aye. Any opposed, nay? The ayes have it. All right, let's see, let's bump down to 1701 and we'll let Senator Sparks explain there's a strike all that you all probably have.
Thank you, Mr. Chairman. House Bill 1701, and you do have a strike all. This will look familiar. This is the language that we had entered on intervention court, where if someone is on probation and they receive a new felony crime and they plead into an intervention court, or if somebody's on probation and they violated and come before the judge and the judge is potentially going to incarcerate them, that if they plead into intervention court, that judge in intervention court has jurisdiction over sanctions, and that if the sanctions are given, and I believe the language that we had in our bill was that if you've had at least 3 sanctions, that if the intervention court judge sentences you to the Department of Corrections, then you are not entitled to a technical violation hearing that is contemplated by someone who is on probation before they go to prison. And the reason being, you already pled into intervention court based on your circumstances. So it just allows the intervention court to actually operate in a fashion and not put someone back in the technical violation hearing process when they've actually pled into intervention court. And we passed this language already in a bill earlier this year.
Okay, any questions? Nope. All right, all for motion?
Uh,
Oh, well, we're gonna need to adopt the strike all first. So any questions on the strike all? All in favor of the strike all say aye.
Aye.
Any opposed, nay? The ayes have it. Now for a motion.
And may I have just one, as far as the language goes, and I will give this to legal, but I want to go ahead and say to the committee, we're using the term probationers, which I think is broad enough. But if someone is on PRS and also has pled in intervention court, we want them to have the same protection, but also the same obligation. So I will, if that needs to be amended, I would do that and explain that on the floor. Thank you.
Okay. So your motion is?
Title sufficient, do pass, strike all as amended.
You heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right, I think the last bill we'll try to tackle here in the last few minutes is House Bill 1577. There's a committee substitute, looks like. And I did reach out to Representative Felsher. He had a different meeting this morning that he had to be at, unfortunately. So he asked us just to consider his bill. This deals with false reporting of child abuse. And I think the new language starts on lines 24 and following. So it's talking about a report shall not be considered filed in good faith under the section when it's unsupported by credible evidence and the person who filed the report intentionally submitted the report knowing that it was false. Such report shall be considered a willful false report of child abuse. And then any person convicted making such willful false report of a child abuse under that section shall be punished by fine not to exceed 5,000, by imprisonment in jail not to exceed 1 year or both. And then it talks about the proof that the person who filed the report reasonably relied on credible evidence or credible information shall be a defense to the said claim of the willful false reporting. And in addition to any fine and imprisonment, upon a proper showing made to the court, the person may be ordered to pay restitution to the law enforcement agency, Department of Child Protection Services for any reasonable costs directly related to the investigation of the false reports. And then it tells you who can prosecute on lines 41 through 45 would be the State Attorney General, Department of Child Protection Services, County Attorney or county in which the child resides, or the District Attorney of the county in which the child resides. And I think the rest of it is just conforming language to that. That's the explanation of the bill. Senator Hickman.
Just quickly, I was just trying to figure out what would be an example of that. I know, I think it has in here like child protective services being some. and it's my understanding that most of those reports are made anonymously. How does that work out? And I'm just trying to see who this would affect. I don't think it's a bad bill, but I'm trying to see how does it work?
Senator Sparks.
Thank you, Mr. Chairman. I think the concept of the bill is certainly a good idea. I think we see weaponization, as you probably see in your practice, of reports. This same thing happened to several legislators here a few years ago, where reports were made that were false. The anonymity of the reporter is a separate issue. I don't know if this bill addresses that, but if something is a false report, that agency knows who reported it. So I don't know how they ultimately will prosecute this. I guess instead of making it a public matter who reported it, if the agency determines this is a bad faith filing, then they would then address that person and they would come to light. But I think it still protects the anonymity of a good faith reporter.
And I guess and I'm guessing that with that, my hopes would be that the agency would understand that, that's important, and someone who maybe had reasonable credibility thought and all that, maybe it'll get to multiple because there are people reporting over and over again. My next question would be, would this affect instances where people are going through, let's just say, a divorce proceeding, and they want to raise child abuse issues, which now is going to cost both parties because anytime you say the word abuse in chancery court, you have to appoint a guardian ad litem and go through all those steps. Would that be something that could then be reported to law enforcement and then be tackled under this as well?
I think it would, because again, the burden is certainly on the state to prove it was in bad faith. But what we have, and I think you've touched on it, not only does it really become an issue in the chancery court process, it also is a burden put upon Child Protective Services. And as we're trying to help Child Protective Services to properly process legitimate cases, people who are coming in and filing what we would call false cases just in retribution for some personal matter or any other matter, I would like to see them prosecuted because that would free up CPS to actually focus on legitimate cases. But yes, I think your concerns are well warranted.
It'll also help me make a little more money because most of the time my clients can't pay me and the guardian ad litem. So thank you.
Be careful, you'll be conflicted on voting on this bill.
Any other questions, Senator Hill?
This is something that many of us have been trying to get done for years and years and years. I'm one of the people who CPS showed up at my house, and I didn't even have any kids. So we know that was a fabricated case. I'm even thinking about a potential amendment that the aggrieved party who had the false claim against them would have to be notified once CPS makes this determination to prosecute, that they would have to notify the aggrieved party of the identity of the person making the malicious report. Because I never could find out who called CPS and said I was abusing 2 children in my house and neglecting 2 children in my house. So I don't know how the committee would feel about that, but I would like to make sure that whomever the false report is filed against has knowledge of the prosecution.
I think, and I understand your point, I think you would have knowledge of the prosecution because you would be the victim. Like if the state was going to prosecute a crime against a false reporter, they would need you to be the victim, and you would probably be witness number one.
Well, I did get a letter from CPS that indicated that they did do something, but they did it without my knowledge. That's why I brought this up.
Sure.
That's
And
been a lot of years ago.
yeah, I think under this law, because they're prosecuting a crime, that definitely the victim would be on notice.
This section deals with mandatory reporters. If you look at section 1, so you're not talking about necessarily everybody.
Well, I think if it's only mandatory reporters, I would have an amendment to expand it to any report. I would have an amendment. I would like to entertain an amendment to expand it to any report of false reporting of child abuse or neglect.
And y'all correct me if I'm wrong, but section 2 says it should be unlawful for any person Yeah, so, and we can, I'll double check this. I'll get with Representative Felcher to make sure. But I agree that it should cover not just mandatory reporters, but any report
Yes.
that's false.
And to just, to,
Thank you, Mr. Chairman, and I'm not sure if we have an amendment. I have what I hope is a simple amendment that I think makes lines 33 to 35 read better if I'm recognized for that amendment. As it reads now, it says proof that the person, I think I understand what Representative Felcher is trying to do there. I would ask that we strike the words proof that and instead use the word when the person who filed the report reasonably relied on credible evidence or credible information, and then put the word it shall be a defense to a claim of willful false reporting. I'm not sure that saying the word proof that, we don't explain what level of proof, why we need proof. And I think what he's trying to do is just set up a situation that if you relied on credible information, it shall be a defense to the claim. I think that maybe will read better and more clearly. Do you see
Heard the amendment? Any questions?
If the person, yes, if the person who filed it, yes. Thank you, Ethan. I think that does read better. But I think it's more clear what's trying to be done with that section. Very simple amendment, but that is my amendment.
All right, you've heard the amendment. All in favor, say aye. Any
Aye.
opposed, nay? The ayes have it. All right, Senator Wiggins.
Mr. Chairman, I think I have a quick amendment as well on lines 40. May I proceed? Lines 42, 41, 42, it says violations and it has may be prosecuted by the Department of Child Protection Services. CPS is not a prosecuting agency. They would make the report and then the Attorney General or the DA would do it. And also, if to kind of Senator Hill's point, they're the ones involved. They wouldn't be prosecuting and being the ones involved. So my amendment would be to strike the Department of Child Protection Services because they are not, and the point is they are not a prosecuting entity.
Heard the amendment. All in favor, say aye.
Aye.
Opposed, nay? The ayes have it. All right. One more question, Senator Hill.
it would go without saying that Child Protective Services would have to report these to that agency, correct?
Yeah, and that's why
So
I mean procedurally.
We wouldn't have to have anything in the law that says they're required to report it. Would we need anything like that?
The way I read it is, I would think most of these false reports go to CPS.
Yeah, they
And
do.
then if they determine I consider them an investigating agency. And if
Right.
they determine
Right.
that it's false, then yes, they would report that
But
over just like some.
I hate to say it, but there's laws right now that Child Protective Services are ignoring that we've passed in good faith and that the governor signed. So, I would hope that they would do what they're supposed to do without the law saying you better do this or else.
Well, I would tell you the incentive, as far as I'm concerned on this, is that they do get these report, and so
They don't, I mean, it
Nobody.
wastes their time. So
right,
if
and
there's,
they waste their time having to investigate those.
Okay,
So
thank
maybe if
you,
they do that, then they know they'll have to deal with less of those.
thank you.
All right. Any other questions for a motion then? Okay, let's adopt the strike all. I'm sorry. All in favor of the strike all, say aye. Any opposed, nay? The ayes have it. Now, Title 52 pass as amended. All in favor, say aye. Any opposed, nay? The ayes have it. Motion to rise and report. Thank you all.